thank you all for being patient as we're enduring this marathon, but it's a lot of great discussion, so I appreciate you guys participating. I want to sincerely thank our sponsors for today's event. McGuire Woods is our platinum sponsor, and we also have Coates & Bennett has been very generous, as well as Myers-Beagle. So I could not have pulled this all together if we hadn't had some funds from you guys, so thank you. Deep appreciation for that. Now I want to introduce Trish McGee, who is then going to introduce our distinguished panel of judges. But to give Trish a little bit of, kudos here, she is a former Camel, which is very difficult to say. She graduated from Campbell Law when it was still down at Bowie's Creek. And as she shared with me earlier, they had nothing to do but study. And it's a lot more challenging now being here in Raleigh. But we thank you for being here. Her undergraduate is actually from the University of North Carolina, or as somebody described it yesterday. Is Mr. Finkelstein here? How did you describe it?
I did that only to a Campbell crowd, and all these Carolina folks. But my brother-in-law calls it Orange County Community College.
So see, I didn't say it. So. To introduce Trish, though, she's a career law clerk for the Honorable Frank D. Whitney, who is the Chief Judge for the Western District. I tried reaching out to both Eastern District, Western District, Middle District, and a lot of them were already busy, but we are glad that Trish is able to be here to moderate and at least represent the Western District, because they do have a little different history when it comes to their patent litigation. So she started working for Judge Whitney just right after he was appointed to the bench in 2006. While she was still in law school, she also was a judicial intern for the North Carolina Supreme Court Justice Mark Martin, who is now the Chief Justice. And she also was a law clerk for the Honorable John Tyson, who's on the Court of Appeals. And this was right after she graduated from Campbell Law. After her clerkship with Judge Tyson, she practiced civil litigation in Charlotte with the firm of Shoemaker, Lube, and Kendrick for several years before she joined Judge Whitney's chambers. Currently, she also serves as the chair of the Continuing Legal Education Committee for Mecklenburg County Bar and holds leadership positions in various other community organizations. Her undergraduate is a BA in Public Policy Analysis from North Carolina, University of North Carolina. Thank you, Trish.
Thank you. And now I'm tasked with giving you the bios of these three extremely distinguished guests, and I could spend our entire 30 minutes delivering their unique and remarkable backgrounds. But I'm pretty sure you'd rather listen to them than me, so I'll try to give you something short and sweet for each of our panel members. First, I'd like to introduce Chief Judge James C. Dever. Chief Judge Dever has served as a U.S. District Judge for the Eastern District of North Carolina since May 2005, and he has served as Chief Judge since October 2011. Before serving as a U.S. District Judge, Chief Judge Dever served as a U.S. Magistrate Judge for 15 months. Chief Judge Dever graduated with high honors from the University of Notre Dame in 1984. He attended Notre Dame on a 4-year ROTC scholarship and was awarded numerous military and academic awards at graduation. He received his JD with high honors from Duke University School of Law in 1987. At Duke, he served as editor-in-chief of the Duke Law Journal, was elected to the Order of the Coif, and received numerous academic awards. After law school, Chief Judge Dever clerked for Judge J. Clifford Wallace on the Ninth Circuit Court of Appeals, after which he served as the, and I think this is really remarkable, sole attorney on active duty in the Air Force General Counsel's Honors Program at the Pentagon. He then returned to North Carolina, where he joined Maupin, Taylor, and Ellis in Raleigh. Chief Judge Dever has taught at both Duke University School of Law and here at Campbell Law School. Judge Louise Flanagan, seated beside Chief Judge Dever, is also a U.S. District Judge in the Eastern District of North Carolina. She was appointed in 2003 and a year later began service as the Chief Judge for the Eastern District until that term ended in 2011. Prior to being appointed a District Judge, Judge Flanagan served as a U.S. Magistrate Judge in the Eastern District of North Carolina from 1995 until 2003. Judge Flanagan received her undergraduate degree from Wake Forest, where she graduated magna cum laude, and she received her JD from the University of Virginia School of Law. Following law school graduation, Judge Flanagan was a law clerk to then U.S. District Judge and now Senior Judge Malcolm J. Howard. Judge Flanagan then engaged in private practice for 10 years, mainly in the litigation area, first with a large Chicago-based law firm in its Washington, D.C. office, and later with a North Carolina law firm, becoming a partner in Ward & Smith in 1994. Judge James E. Gates, at the end of our table, has served as a magistrate judge for the U.S. District Court for the Eastern District of North Carolina since 2006. Prior to that, he practiced business litigation at a mid-sized law firm for 20 years. His previous work also includes private practice in Washington, D.C. Judge Gates received his undergraduate degree from Ursinus College, where he graduated summa cum laude, and he received his law degree and a master's degree in foreign service from Georgetown University. Following graduation from law school, Judge Gates clerked for now retired U.S. District Judge Frank W. Bullock, Jr. in the Middle District of North Carolina. Judge Gates is the principal author of the 5-volume North Carolina Civil Trial Guide, and he has taught a class on federal practice and procedure also here at Campbell University School of Law. Thank you, Your Honors, for being here today. I'd like to start with a somewhat generic question to help the audience get an overview of patent litigation as you see it in the Eastern District of North Carolina. I understand that there has not been a patent trial, but have you observed any trends specifically related to patent litigation here?
I was telling Judge Devers before we began that I can run the statistics, and they're fairly constant over the last 10 years. We had 2 aberrant years that really is explained because of the number of related cases that were filed. But we average between 8 and 11 cases, and that's been consistent.
Selfishly, I'm curious about this, the Western District of North Carolina recently, a few years ago, adopted local patent rules and admittedly modeled those in large part after the Eastern District of North Carolina, knowing how much work was put into formalizing those. Have you all found that helpful in managing patent cases, and have you seen any evolution in those at all as they've changed since you've had them longer than we have?
I don't think in terms of the case statistics that Judge Flanagan just mentioned, we haven't seen a statistical change in the number of cases that get filed here. They certainly try to channel a process in connection with the cases. Judge Numbers did just introduce himself to the audience, and he is, we just appointed him chair of our patent rules committee. The rules were adopted when Judge Flanagan was the chief judge. He spearheaded that effort, a very important effort. And the other, just so that you know who the other members of the committee are, it's not some exclusive club, by the way, but Professor Rise, our academic, Lance Lawson of Myers-Beagle, Rick Matthews of Williams-Mullen, Susan Olive, and Carl Sanders of Kilpatrick Stockton. And again, at least a little bit of a discussion of the last panel's comments, or suggestions or something. We are going to systematically, I've asked Judge Numbers to systematically go through with the new committee, and with input from everyone. There's obviously a notice and comment period about what is working, what is not working. Obviously, it's not all folks who do defense work or plaintiffs work. Any of the local rules process, you're trying to get input from folks who participate from both sides to try and get a workable and fair set of rules. So that's certainly, that's the process that we're just starting. The rules have been in effect since 2007, and part of what I would hope as the committee will do is get input from practitioners on what seems to be working, what suggestions that there might be for improvement of the rules. So that's
from a judicial side, at least the comments that I've heard in the Western District, because they are relatively new for us, is the judges really appreciate that it's pretty specific about how the case is going to go from start to finish, even though in the Western District it's a 2-part order. You have an order to claim construction and an order following. Could y'all comment on how you felt, at least case management-wise, that that helped facilitate the patent cases?
I'd be happy to answer that, but I'd like to follow up on some of Judge Dever's comments, because I was chief judge in 2007, and the court did task the master judge, now retired Judge Webb, to chair that committee. And there are probably some of you in the room who were on that committee. My conversations with Judge Dever, with Judge Webb, indicate we did not model the rules after the Eastern District of Texas. We drew down, and you compliment us on our hard work, but I think I need to say Judge White in the Northern District of California, who I think many consider the founding father of these local rules. Judge White did a lot of work, and we modeled our rules off the Northern District of California and the Western District of Pennsylvania. And I dare say the Eastern District of Texas probably looked to Judge White and the Northern District of California as well. Now, coming to your question, I think we draw down the success of these rules around the country, and I think they are helpful to the cases and moving them along. I think there is room for improvement as well.
And I will say, in response to the question, it is or the observation about, is it better if there's a firm trial date? Well, it's like I tell the students, safest answer in law school, right? It depends. Right? The reality of it is, if you have a firm trial date, and there are pending motions, and you get motions from the lawyers. Well, my client's really concerned. We're going to spend all this money getting ready for a trial that might not take place, right? So that, and I remember having those conversations when I was a lawyer with clients. It means, what do you mean you have to get ready? Do you know that this motion may make the case go away, but we need to spend all this money getting ready for trial if it really is firm? And so, I mean, it's an interesting, and I realize there are some districts that do it, but I think it does create some tremendous inefficiencies and drives up the cost of the process. If you did, and I would never actually see divesting a given judge of his or her discretion on when to set a trial date, but I think setting a trial date at the very beginning that you then don't move off of can create higher costs in the litigation, undoubtedly. I mean, I think it's something for the bar to think about. Is that really the way it was?
That leads actually into the next topic I would like to discuss, which is the motions practice. That is a battleground in complex cases for sure. From the beginning a case is filed. And you may disagree or agree, but I have heard some judges say that less is more when it comes to filing motions and briefs. On the other hand, attorneys often feel compelled to match either the length or the number of briefs filed by their opponent for fear of reflecting a weaker argument or a weaker position. Can you give any advice for attorneys as far as maybe preferences you have for motions practice and how to deal with a prolific filer as an opponent?
Why don't we start it with Judge Geeks and work our way this way?
Well, I don't think on a blanket basis you could say, I wouldn't say shorter is better. It depends on the topic. Content rules. If a matter necessitates a lengthy brief, then it really ought to be lengthy. If it doesn't require that, then it ought not be lengthy. That's one observation I would make. I also think that we have the flexibility of fitting the process to the dispute. And I know in the Middle District, I believe they have rules on abbreviated briefing and abbreviated hearing process for certain discovery disputes. I've entered orders in cases where having an abbreviated regimen like that available to the parties, not necessarily imposed against their will, but having limits on the length of brief for particular types of disputes actually facilitated the process significantly. Really proved a boon to move things along. I would say that if you really think you need more, to say more than the rules allow, file a motion. If you need a hearing, file a motion. Let the court know. you've really got something that's significant to say that will help the court decide the motion, put that issue before the court.
It's very well said. I'll just throw out a nugget. If you're not going to reply, you could call the case manager up and say there'll be no reply, and that way the briefing will be deemed then right and will come right away to the judge.
I think on that last point, again, one difference in terms of when you're trying to decide motions compared to practice. In practice, right, you're getting the service, and then you immediately have to read it, and you have to file your response. As wonderful as the memos that you all file are, I can assure you that when it's not right, that is to say, I don't have the plaintiff's brief, the defense brief, and the reply brief, I'm not going to sort of spend a day or part of the day reading the plaintiff's brief, wait 20 days, read the defense brief, wait 10 more days, read the reply brief, and then kind of reorient. So to Judge Flanagan's point, that if you're not going to reply, then the judge knows, it's like, all right, this is now ready to be read and decided. That is a helpful. I think there is much truth to the adage that the lawyer apologizing for a lengthy brief and saying if I had more time it would be shorter. That you really that I think less is more in terms of getting to the point of what it is. I also think just in terms of the front end consultation and building things into a scheduling order. I know in some both patent and non-patent cases, if the lawyers suggest that they would like to have that they anticipate, trying to work things out, but they want to have the ability to have a telephone contact with one of our magistrate judges, and if issues do come up or hearings, I know there have been more than one case where Judge Gates has done that and gotten to sort of resolve and deal with a lot of discovery-related issues and kind of keep a case moving along. But again, I look at that there's a cultural component that I remember in practicing here that I still think is present here, is that the lawyers cooperate with one another. And my sense, at least when I remember when I was a lawyer, I want to get whatever the schedule was and then just work up the case one way or the other, and then as needed if the judge needed to intervene, but we didn't sort of go in with the assumption that there was going to be a need for a lot of that. But if there is, if you anticipate or you think there's something special or something unique about your case, to notify us after you had your conference. I'm very open to that, and I've done it. But again, it's a matter of if the lawyers don't tell me that that's something that they think they need, then I'm operating on the assumption that they're going to handle the case. Cases have gotten handled in the Eastern District of North Carolina for years, that people are going to zealously represent their clients, that they're going to be cooperative with one another, and sometimes you do have to come in and get a ruling on something and to accommodate. And sometimes it can be, we don't even need to fully brief it. We can just get a sense of things. I know Judge Gates has handled that. I know I've handled that.
Can I pick up on a few of those?
Absolutely.
Second point that Judge Jefferson started by making, which is we likely don't read these briefs when they're filed. We likely read it when everything's right. Now, there are exceptions to that. We have very skilled case managers, and if they discern something is brewing, they'll bring it to my attention. And we also have, as of last year, largely through one of Judge Gates's chamber staff, his career law clerk, helped us immensely develop our own computer program. Ian Erickson, my career law clerk, is sitting back as instrumental to this as well. It took only 4 or 5 years, but we now have the ability in the Eastern District to populate our own systems of managing cases with directly extracting it out of CMBCF, and we can order it, we can do all sorts of incredible things with data. And I think if the nation knew that they would want it, but we've got the AO in Washington thinks that we can all figure out what we want out of CNBCF using their reports. And we as judges feel like, they really didn't get us where we need to be. So I think perhaps you all probably have similar programs of the journalists. 2 points. One is don't respond to a summary judgment motion when you think you really don't have all the evidence and you bury in your brief that you need to be doing some more discovery. And then I look at it 90 days later and I think to myself, if they had filed a motion saying they couldn't respond to the motion for summary judgment for these reasons, it would have come right to my attention. And I think of all the efficiencies that could have accrued by stopping the briefing, allowing the time for discovery, assuming I thought it was meritorious. So things like that is don't bury in a brief something that really should come to our attention. And a great vehicle for bringing things to our attention is Rule 16. Rule 16 is a wonderful rule that tells a judge you can have a conference anytime if it's going to promote efficiencies, keep costs down, promote settlement. You know what's going on in your cases per se. We don't really know. Of course we don't know. But if you see something that you think would benefit your client, the case, the just, speedy, and inexpensive determination of action, that's Rule 1. Use Rule 16 to bring it to our attention. Try to get consent from opposing counsel, and then help yourself out even more by offering pre-proposed dates, alternative dates of availability. That's something that's going to get to us pretty quickly. And we review in the patent local rules, you've got Rule 302.1b. It imposes an obligation on you as practitioners to alert us if there's a need for a further scheduling conference in certain circumstances. So really remember that and use it.
May I just add one point to build on what Judge Flanagan said? I've had the experience, I think, and my colleagues have too, of finding out in the, say, right at the end of a motion that the party is requesting expedited ruling. And you get there because of the referral process, it may be 30 days or whatever after the motion is filed. And you almost have a gee whiz kind of feeling. If you really need an expedited ruling, make it a separate motion, because that will get the attention. Putting it in the back of a memo or at the end of another motion as a separate request, even in the motion itself, isn't, in my experience, sufficient. It should be a subject of a separate motion.
We have between 500 and 600 cases, the acting judges. So I think that accounts for a lot of, it should propel you to be alert, to alert us.
That's great. One topic that I'm not sure how much is dealt with here, I know in the Western District we've seen it a few times, is sealing of filings, talking about motions and supporting documents. And basically there are motions that are made to seal. Sometimes there are not motions that have been made to seal. But basically, what advice can you give practicing attorneys about how to treat information that they do not want disclosed to the public and how they want the court to treat it?
I think under everyone's got to remember that there are constitutional and common law principles at play in connection with sealing records. We don't, as a general matter, have secret proceedings. Again, parties can, by contract, say we're going to do everything by arbitration, right? But if you're in federal court, we're subject to the Constitution, the common law, and we do have processes for things to be sealed, and things are going to be sealed while the motion is pending, but certainly the Fourth Circuit and Supreme Court have been clear, and I think you should be, and there are some things that should be sealed, right? I mean, in most of the litigation that y'all are going to conduct as members of this bar, there's going to be a protective order in place, there's going to be confidential information, there's going to be attorney-eyes-only information, but in terms of filing the memos and whatever else, I mean, exhibits are different because a lot of times the exhibits, it's clear why they're asking for it. But to the extent that there's 5 pages of a brief or longer that's describing the the advocate's view of some Federal Circuit cases or some Supreme Court cases in the midst of a 30-page brief. The whole brief doesn't need to be sealed, right? I mean, and so asking for the whole thing to be sealed just out of inertia is not a good practice. I mean, it is. I don't think I've ever had a hearing on something that is clear where it's some technology where it's just self-evident why the lawyer wants that part of the case sealed, where you can see it on the discovery stamp and whatnot. I'm not going to sort of overrule that or override that, but to the extent that there's 2 pages on what the summary judgment standard is, or what principles apply for claims construction, or the introductory part of the memo, that should be nuts. And it's incumbent on the lawyer, I think, to recognize that and to say, we're seeking to have part of this. And to go through it instead of just saying, well, we'll see if they seal the whole thing. If they're paying attention when it's clear that the Constitution and the common law require us to pay attention, and so we will.
Chief Judge Dever, go ahead. I just was curious if y'all have a preference for filing with a full brief with redacted provisions and a separate brief that is full, so that one's on the record.
Yeah, I mean, I certainly, it's been my, and this is, I'm not saying that most practitioners don't do this. I think that the better ones do it, right? They file a brief that is under seal, and then there's the part that is that's been redacted of what they view the public should see, right? So that when I'm reading the I'm not sort of saying, I had to kind of go on 2 different pages, and then I was like, pages 1 through 4 are here, and then I have to go to another document on CBC. I have to read that on this other screen. I mean, it's easiest to read it all at once, but in terms of a sealing motion, the part that is sort of the general discussion of the law, which I think is the most obvious one, or the general description of the case at the outset that doesn't get into the details of the IP or something, that shouldn't be sealed.
Judge Gates, you have.
Well, I was
And then I think we have some questions.
The one, I would add that the motion itself cannot be sealed because the public is entitled to notice that a party seeks to have something sealed. That's not hard to deal with. Just don't put any confidential information in the motion. And Local Rule 79, Civil Rule 79.2, and then Policy T in the CMECF policy manual really it's a cookbook for how to file motions.
I think we have a couple questions from the audience. Professor Osborne, you were first, and you're in charge.
Definitely not in charge. In the last panel, we heard a lot about the Eastern District of Texas, and a lot of people who feel like the Eastern District of Texas is a jurisdiction with a self-imposed mandate, an agenda. And there's a lot of people that criticize it. The courts shouldn't have agendas. At the same time, we've heard from local companies saying that these are some things we like, and we understand that these things are in their self-interest, but courts can't or shouldn't play favorites. So I was curious if you have any thoughts that you can share about what can the judges do to try to address these concerns. I think the local rules is a great start. I don't know if there's any other things. I just thought I would ask the question if there are other things that are appropriate for judges of the court.
Well, I think part of the discussion today. I haven't been here for the whole conference, but I've seen the last 2 panels are just from doing this for a while, both as a lawyer and as a judge. There are some things that are out of the court's control and out of some companies' control. Right? If you get sued in the Eastern District of Texas, and the principles of personal jurisdiction are what they are, and venue rules are what they are, a judge on our court has no control over any of those issues. and whether it's filed there or filed in the District of Delaware. And likewise, I think in connection with applying principles in a statute, I would think most would agree that it would not be appropriate for a judge to say his or her thumb is on the scale, and this is a hometown company. I somehow should rule differently because of that. I think that would be fundamentally inconsistent with my permission and oath of office to do that. And so I think some of the larger issues about how it is that cases get here or don't get here, people don't have any control over. But I don't think it would be appropriate to construe a statute or a case or that to me is not some factor that would be appropriate, not just in patent or IP cases, but in any case.
Yes, sir.
Hi, Daniel Becker, solo patent attorney. To some degree, you just answered part of the question I stepped up to ask about. It was about what would it take for you to want North Carolina to be a forum for federal precedents on the matter. In the previous panel, there was much discussion about a critical mass of cases, and that would require, I guess, something starting the ball rolling on a perception that this was a welcome forum for it.
I think I'm looking at it. It's up to you all. We don't file our own cases. I've tried more men for terrorism charges than any judge in North Carolina, and I don't think it's because the U.S. Supreme thinks I'm energetic for terrorism.
Thank you.
I think we have time for one more question, and then we'll.
Julio Garceron from CRE. I just wanted to clarify something if I came across differently. I'm not suggesting at all that we want any favoritism. No, and either way, I love the North Carolina. I don't know if you heard that before, but I love the North Carolina judiciary. But I was not suggesting favoritism. What I'm saying is that this is the home of the Research Triangle Park, North Carolina. There's an ever-increasing amount of technology companies here. It just behooves the judiciary to be able to be there for that type of critical mass of technology companies to be able to handle technology cases and I'm not saying you can't, but and I understand you have constraints with criminal dockets and numbers of people that can. It's only so much things you can do. But just wanted to clarify. That's what I'm talking about, not any favoritism. If I bring a bogus patent case, then I hope that you'd bring an early summary judgment motion and grant it. So just wanted to clarify my commentary.
We don't bring motions either.
I understood.
But, no, I mean, I think the point is taken, and I at the same time, I wouldn't want anyone to think that I or any of my colleagues are not receptive. I mean, but it's like Judge Brennan just said. The cases that you get are the cases that we get. We don't file the cases, and we certainly do our best to try and handle them efficiently and work through the process. I do think with like the reinvigoration of the local rules committee with input from practitioners, there's an opportunity now that those were adopted in 2007 to say, well, what? And again, it's from the practitioner's perspective that what is working, what isn't working, and it's from the practitioners on each side, right? It's not just the defense side. It is getting input from everybody on what seems to be working, what doesn't seem to be working, I don't have any doubt that part of that review that the committee will do is looking at not just that input, but what are other courts doing that seem to be working or not working with their local rules. All with fundamentally, I think, Judge Flanagan hit the nail on the head, the just, speedy, and inexpensive determination of the case. Right? I mean, that's what we're trying to do. And to the extent that we can have rules that are applied neutrally to make that happen, that's in the interest of everyone, I think. And
you know, we report to Congress every 6 months on our status, and I think while we have one seat that hasn't been filled, and we do look forward to another judge on the bench, I think you'll see when these statistics are reported, we don't have a lot of motions that are pending more than 6 months. We move the cases out. We work very hard to do that, and you work very hard to do your job too. And I've tried, I looked it up to get ready for this. I've had a total, since 2004, I've had 26 patent cases. We've had 119 filed in the district between 2004 and 2014. We stand ready to do what we're asked to do.
And I will add, one of the earlier panels was interesting. I mean, I know, and again, it's the new law, and I suspect, because it's not a joint motion, right? The whole IPR process is in part designed to try and at least send some issues to back up to DC to the three-judge PCAP panel to review those issues, which obviously then with different standards. I mean, obviously that was a part of a legislative give and take, but I don't think it's going to be just in our district. But I know anecdotally in the ones that I've had those issues come up where one side is asking that the matter that there be a stay while the inter-parties review is done, and an explanation of it's expedited, and there is limited discovery, and that this will move the case along. I don't know. Again, I don't know if I suspect from the two panels ago that that's not simply limited to our district, that those motions are being made in a lot of cases, and then that itself is a way that a lot of times the matters get resolved one way or the other. On the topic, I know one of the
Yes,
we do have one of the panelists mentioned settlement-related issues. Again, we have willingness and our magistrate judges will have for those settlement conferences. Again, it's a matter of timing on things like that, of y'all letting us know when you might want that to happen. About when you want that to happen. If you want a court settlement conference earlier in the process, let us know. Or if just one side does, I mean, it might not lead to much resolution if only one side wants it. But again, I mean, we really do look carefully at that to try and help for there to be some resolution of the case, whether it's through ultimately something getting tried or not.
If I could just quickly follow up. First, I'm grateful for this program, and grateful to see so many people. And I got a chance to learn too as I was preparing for it, kind of rereading our local rules and looking at some other districts. And I returned back to that Patent Local Rule 302.1b that I mentioned, that imposes an obligation on parties to alert the court if there's a need for a further scheduling conference in certain instances. And I think I'm detecting in other districts an evolution of the other instances to include settlement. So I think, I wouldn't be surprised if we don't tweak our local rule a little bit there, and really, again, open up the avenue for you to request a conference with the court in furtherance of that instance, the process of settlement. I'd like to ask a question. How many of you rely or have relied on resources in patent work for produced by the Federal Judicial Assembly. And I see a show of hands. Okay. I was thinking what I could do to be of assistance, and I have some links to some information that might be helpful for you. You can get the manual that we have that guides us in patent cases. And I think as a practitioner, you probably want that. And so there's a wonderful amount of a wealth of information, and I've got the links here, and I'll just leave it if you're interested.
If you guys want, I can put those into an email and shoot it out to everybody who is registered because they have all your email addresses. Does that work?
Thank you, judges. This is, again, a very distinguished panel. We appreciate your time and honest answers and the insight, especially into how the practicing bar can improve in practicing before you. So thank you very much.
Folks, we'll take about a 5-minute break, and then we'll hear from Judge Michelle. All right, ladies and